Today, we deal with the concept of bail. So, first, you come to the definition of bail. What is the meaning of bail? The court held that there are several understandings regarding the concept of bail. So, according to the Supreme Court, in several judgments, the whole concept of the meaning of the bail is surety. The surety. If we enlarge this, if we go into the details, the bail is, in fact, there is no any definition uh, defined by the code regarding this bail. It is nothing but a surety inclusive of a personal bond. Surety means not by third parties only, even it includes personal bond also. Personal bond also. So it is an inclusive point. Release of an accused person either by the orders of the court or by police or by the investigating agency. So bail can be granted as told earlier. It can be granted by court, police or investigating agency. So this is bail. Surety, otherwise also known as security also. Security. Security for what? Surety for what? To appear in the court, so on, so on, already we discussed. So the literal meaning of the bail is surety. Includes personal bond. Okay. Then today topic is to cover the concept of the whole bail from investigating stage to investigation stage. From the stage of investigation to total revision up to revision. That means normally bail, several people think that bail during investigation only. Even some of them think that bail up to either conviction or acquittal. No, it extends to appeal, and also it extends to revision. So for the purpose of the bail, the definition of trial, here we are seeing trial definition. For the purpose of bail, the definition of trial should extend up to final conclusion of the trial and appeal and revision. So this is a extended definition. This is extended definition. Next. Come to categories and types of offences. Supreme Court has given some division regarding total offences, because Supreme Court is with a view that the trial courts are not in a liberal in granting bail, and personal liberty is very precious in view of Article 14, 21, 22 and other things. So keeping the prevailing situation in India, Supreme Court is under the impression that certain guidelines has to be given. That's why these guidelines have been given uh, in judgment. Okay, now what are the categories? Supreme Court has divided offense into 4 types of categories. Category A, Category B, Category C, Category D. So 4 types of categories. What are these categories? Category A, below or up to 7 years. This is one category. Category B is above 7 years. And category C, this is special acts like UAPA, NDPS, offenses under the special acts. Because please mute your mic. So UAPA, NDPS, such type of special acts. Next category D is economic offenses. Economic offenses not covered under special acts. Special acts. Economic offenses, but not under special acts. So, Supreme Court, for the purpose of bail, it has been categorized the whole offenses into these 4 categories. So, basic, what is the basis for this division? The basis for the division is seriousness of the offense. Seriousness of the offense. Basing on this category, Supreme Court given guidelines to follow how to approach these accused persons. I think this is the whole topic to be covered either today or tomorrow regarding the concept of bail. This is the whole sections and the whole topics. So if anybody wants, you write it, or otherwise I'm going to delete this. So can I delete? Because we are going one by one. This is the whole topics covered under the heading of bail. Because till now we have covered arrest. So bail is also the part of investigation. When arrest is there, it is also part of course, automatically bail also comes. So I am removing now.
Sir, how police will give the bail, sir?
I already told you.
Is any section, sir?
That's only you did not attend previous class.
No, sir.
Then how can you understand? Section 59. Police can release them on personal bond.
Section under section 59, sir.
Not only 59, police can release them on a personal bond, but 59 specifically says that. You see what is
Okay.
59? Do you have a book?
Yes, sir.
Read 59.
Discharge of person apprehended.
Uh,
No person who has been arrested by police officer shall be discharged except
uh,
on his own bond on or bail or under the special order of a magistrate.
what does that mean?
No person who has been arrested by police officer shall be discharged except on his own bond, sir.
So by taking personal bond, own bond means personal bond.
Okay,
By
sir.
taking personal bond, police officer can be discharged the accused. Discharged means release. Because police cannot discharge like courts after appreciating the evidence and other things. Here discharge means releasing on bail. So that is police can grant bail. Okay.
Okay, sir.
Now come to types of categories already we have discussed. Now, what is the point of the court is if the accused is cooperating with the investigating is he can be taken in a liberal approach. Court or police can take liberal approach basing on the behavior of the accused. How we know the behavior of the accused? So these conditions has to be taken into consideration. What are those? No arrest during investigation. Suppose no arrest during investigation means what? Now liberty has been given to investigating agencies whether to arrest or not, basing on reasons. Already we discussed that. So no arrest has been taken place during the investigation means that investigation agency did not choose to arrest the what do you call accused because of so and so reason. What it indicates? It indicates there is no necessity to arrest of the accused. So what happens? He did not arrest. So in another way, 41A notice can be issued. 41A notice and the conditions of 41A notice are being implemented. So investigating agency did not arrest him. So that can be draw in inference that he is cooperating with the investigating agency. So this is one condition to be taken into consideration. Next, cooperation throughout in the investigation, including appearing before investigating officer whenever called. That is also one of the, already it's covered in the above matter. Whether this accused is cooperating with the investigating agency or not, whenever called he is coming or not, whenever asked him to comply the certain so and so condition, he is complying or not, all these things have to be taken into consideration. So these are the requisite conditions to be taken into consideration. Then by taking these conditions into consider, suppose if the offense falls under the category of A, that means what? Below 7 years. Below 7 years. So if it is the offense of below 7 years, first what is the duty of the court? Only summons has to be issued. What is that? Summons. Summons has to be issued at first stage. And also permitting appearance through lawyer. That means, suppose section 205 is there, special wakalat. If it is a summons case, even special wakalat, not only special wakalat, permitting appearance, how appearance should be there. How appearance should be there? Appearance through lawyer also can be permitted. No need of appearance of accused for all adjournments. That is the concept of the court, Supreme Court. Why? Because personal liberty is precious. That's why this class is very important. I don't know why several people did not attend. Of course, it may be a gap. We are not taking regularly. That's why people are may not coming. But this class is very important. Whatever I am choosing to say, those are very important, not only for JCJ exams, even in practice also, these are very important. We are asking as a lawyers, we are asking the people to attend regularly. But there is a chance. What is that? Now, Supreme Court is viewing very serious if personal liberty is being deprived regularly. So a very liberal approach is being taken by Supreme Court. That is very useful to the practicing lawyers in trial courts and magistrate courts. So one way we can file bail applications. In another way, bail is not filing application for bail is also not required in several cases if you understand this class. That means it is a judgment of Supreme Court. So below 7 years case, we must, the court should first instance has issue summons and even permitting the accused appear through lawyer. That is one case. After this step, if this step is not complied by the accused, if the accused does not appear despite service of summons, then what is the another option available with the court is bailable warrant. It is bailable warrant, not straight away NBW. Directly, court should not give non-bailable warrant. Only for purpose of the physical appearance. Suppose in case even after bailable warrant he failed to appear, then non-bailable warrant can be issued. Even after issuing NBW, he did not fail. Suppose after issuing NBW, he wants to appear, then what is the procedure? Cancellation of NBW. So even court can cancel NBW because why accused not appeared? There may be several reasons for non-appearance. Normally, there may be communication gap between lawyer and client. Or there is any health reasons. Or there may be any emergency reasons. So, there may be several reasons for non-appearance before the court. We can't take them, it is a contempt of court because they have no respect towards court, they did not appear. We can't take in that view. So that's why there is a cancellation of price, this NPW. Either cancellation or convert into PW. When cancellation of NPW take place or convert into bailable warrant. So normally court should convert or cancel this without insisting physical appearance of the accused. It is also important. Here, when earlier that was there, when NBW has been issued, accused may fear that if I attend before the court, court may arrest him and send him to jail. So here the question is whether physical appearance of accused is required when filing of recall of NBW. So anybody knows under which provision this recall of NBW will be filed? Tejaswini, are you practicing or only reading, studying? Hello? So when physical appearance, physical appearance may not be required. When recall of NBW application has been filed. So without insisting physical appearance of accused, that can be converted. But what is the condition? Undertaking has to be given by the accused. So what is the condition? Undertaking. Undertaking for what? Undertaking for appearance. For further appearance. If suppose accused appeared, has given undertaking that so and so reason I could not appear before this court, and I will give undertaking that I will appear in future courses, future adjournments, then by taking this undertaking, the court can convert or cancel the NPW. So this is the procedure regarding cancellation of and next bail application. How to decide bail application? Even in these cases, such cases, without the accused being taken into physical custody while deciding bail application, they have no need to take the accused into physical custody. Suppose if he has been taken into physical custody, interim bail can be granted. Interim bail can be granted. So this is the dealing of the category A offense regarding bail and production of appearance. This is A. Next, category B. Category B is something more serious than category A. Then how to deal with this? Category B and D. D also economic offenses. So only on his appearance, on merits, on his appearance. So when accused appeared before the court, merits of the case, basing on merits of the case, bail application has to be decided. category B and D. B is more serious, D is economic offenses. Here, Supreme Court categorized look at the economic offenses as a serious view. Of course, not all economic offenses will be looked into the serious use. Economic offenses may be various types. There are many types of economic offenses. So what court told about this B and D, merits of the case, you have to decide. There is no any a jacket type of formula. That is category B and C. B and D, not C. If you come to category C, what is category C? Category C, special acts, offenses under special acts. These special acts are having some extra provisions. These are having extra stringent provisions. Normally, liberal approach will give to bail, but special acts not give. Special acts look the accused and the offense in a serious view. Suppose UAPA. What is the UAPA Act? Unlawful Activities Prevention Act. That means terrorism, such type acts are. So because of the seriousness of the offense, bail normally will not be granted in a liberal way. So there is a procedure, there will be a procedure and special acts. No need to grant bail, so and so date, so and so period. Suppose 3 months, 9 months, 6 months, like that. So basing on that provisions and basing on the merits of the case, these accused will get bail. So this is the concept. Total 4 types of categories are there. First is below 7 years. Second one is above 7 years and more serious. And third one is these special acts. The fourth one is economic offenses. So economic offenses and B category, that means more serious offenses can be dealt with on merits of the case, on appearance of the accused. So accused appearance is must, that you have to keep into brain. And regarding the C special acts, you have to take the consideration of the special provisions into thing. And other thing is B and his appearance also should be there. So this is regarding 4 types of categories, how court should take care. Even now, this is the liberal approach, but these guidelines may not applicable. These accused, if they did not cooperate with the investigation, if they did not appear before the investigating officer when he was called for. So when he did not answer summons, when court feels the judicial custody. So basing of the behavior of the accused, these guidelines, these liberal approach may be not applicable to him. And in the same way, suppose if any further investigation is necessary to recovery, suppose some recovery is required in that case, for that purpose his arrest is necessary, then it will be a different footing. So all these things are taken into consideration while deciding these things. And another thing is, interim bail also can be granted. There is nothing is prevented the court granting interim bail, taking into consideration the conduct of the accused. That can also be granted. So this is regarding 4 types of offenses and how to dealt with these 4 offenses. And also I explained what is the definition of bail, what is the extended definition of trial. Now we go to further chapters. So what are the further chapters? You see, bail is required under several circumstances in the code, several stages of the offense, investigation, trial, trial, appeal, revision. So there are several stages. Suppose you take 87 and 88 of CRPC. What 87, 88 CRPC says? Even this 87, 88 regarding issue of warrant. Issue of warrant. And 88 says power to take bond for appearance. Power to take bond for appearance. What does that mean? Power to take bond for appearance means granting bail. Granting bail. So, court is empowered to issue warrant even in lieu of summons. That means what? When summons is required to issue, suppose court feels that any manner of otherwise, court feels that he may not appear for the summons, court can issue warrant. That power is there with the court. It is only discretionary power. It is only discretionary power. So, how to exercise this discretionary power? Only after exercising the other method, other liberal methods. Because of you are having discretionary power, you can't issue straight away warrant in lieu of summons. What is the difference between summons and warrants? Summon is a less coercive step when compared with the warrant. So summon is only asking him to appear, but warrant is asking him compulsorily. Otherwise, by force, warrant will bring him to the court. So warrant is a coercive step comparatively summons. So when you have discretion, it should be guided by judicial principles. Judicial principles. You must keep this point in your mind. This will come several times, not only in bail and other things. An entire judiciary, you want to become a judge. So this, of course, you are having some discretionary powers. It should be exercised by this judicial mind. It should be guided by judicial principles. So When court issues either summon or power, if he appeared, court can take bond and release him. When he appeared, execute a bond with or without securities. So this is another situation where bail is to be required. Next, see section 170. 170. So what section 170 says? 170 is after completion of the situation after completion of the charge sheet. Investigation. Suppose upon investigation officer in charge of the police station feels that there is evidence or reasonable ground, then what is the duty? Forward the accused under custody to a magistrate empowered to take cognizance. It is sections 170 mandates. So, after conducting investigation, there are two options available with the investigation officer. You know that already we covered this investigation. What is that? Filing of charge sheet, one option. Filing of charge sheet or challan or final report is one option, or filing of closure report. It is also called final report. So these two options are available with the investigation officer. When charge sheet will be filed? When evidence is available, charge sheet will be filed. When no evidence against the accused, then he will file closure report. This closure may be, there are reasons, regular reasons like mistake of fact. Mistake of fact or mistake of person also. That means what? Mistake of fact means the entire incident is mistake. Mistake of person means that offense is there, but not against the accused mentioned in this FIR. So when these two options are available with the investigation of officer, so when he found the evidence or reasonable ground also. So what is his duty? Forward the accused under custody to a magistrate. Then what is the duty of the magistrate? If it is bailable, if the accused is able to give security, then the magistrate, the court shall take security from him for his appearance for next hearing or further hearings. Then he can be released. So this is the power of the section 170 with the magistrate. Here it is the duty of the magistrate, but the duty of the police is he has to forward the accused with the custody according to section 170. But in Siddhartha versus UP, state of UP case, Supreme Court in 2021 judgment, it is 2021 judgment, Siddhartha versus state of UP. In this case, Supreme Court says there is no need to forward to accused. there is no need to forward accused under section 170 of CRPC. This is the law laid down by Supreme Court. So for every time, just because police officer is going to file charge sheet on the ground that he found some sufficient ground or evidence, no need to forward the accused to the magistrate. So this is another situation. So there are so many situations under the code where bail is required to the accused. So we go one by one. After section 170, 204, 209 is there. Thereafter 319 is there. Thereafter 389 is there. Thereafter 436, 437, 439 is there. 430, 440 is there. 436A is there. So on these several situations, accused is forced to obtain bail. But in all these matters, the Supreme Court has given some directions. First, we have seen some of the categories and the methods. Finally, Supreme Court has given some directions. We will go one by one. So, investigation stage, trial stage, and even after under trial prisoners, UTP. Under trial prisoners means the accused who are in the jail. So they are also entitled for jail. I forgot a very important section, that is 167, remand. So when bail is, how bail will be granted under section 166, 167, and default bail. This is also very important topic. Definitely we can expect a question, short or big question on this default bail under 167 clause 2. So because of this few member today, I want to stop here and I will continue tomorrow. Tomorrow there will be a class. I will send the Zoom link. Okay, can we close?